In this video, we're going to talk about student loan discharges. What's the difference between private loans and public loans? You're going to hear right now from somebody who's been doing this for 18 months, has a 100% success ratio. My name is Philip Tyrone with 720 System Strategies. We help consumer bankruptcy attorneys market their business and become more profitable. Today, I got Ken Neely on the line. He's been attacking the student loan discharging over the last 18 years under the Bruner guidance. Now, under the new guidance that was released on November 17, 2022, it's becoming a lot more easier. Under the new guidance, everyone thinks it only has to do with federal loans. Not the case. Ken, good to see you.
Hi, Phil. Good to see you too.
Okay, so everyone thinks, as I mentioned, just got back from NACBA. When I bring up public and private student loans, everyone's like, oh, it has nothing to do with private. Oh, no. This is just federal student loans. I'm like, no. Private loans can be discharged. And I got you as the expert proving my case because I've learned all this from you, frankly. So Ken, let's speak into that.
Yeah, you bet. So there has been a lot of attention on student loans recently in the news, in politics. Everyone out there who's familiar with student loans knows there's a massive amount of student loan debt out there, 2 trillion. So it's a big problem. And about 18 months ago, as you mentioned, we really started attacking the myth that this belief that there were no options for debtors in bankruptcy to deal with their student loans. And what we found is that even under the pretty rigid Bruner standard, we were able to reach great settlements with both private student loan lenders and our clients with federal student loans. But what we almost universally found was that it was easier to deal with and easier to settle and easier to discharge the private student loans. Okay. Why is that the case? I think it's the case because a private student loan lender has to make a calculation of cost benefit, right? Do I spend money to fight this discharge, hire an attorney, even have to potentially take it the whole distance to protect a $35,000 private student loan? So sometimes there's just not a return on that investment. And so when you're dealing with private student loan lenders, you're dealing with more of a business decision. You also have additional arguments with private loans that you don't always have with federal loans. And so that can really bolster your case and make your case stronger. And I will tell you that it is a total myth that you can't do anything with student loans in bankruptcy, and especially when that comes to private student loans. The success rate of full discharge on our private student loan cases is, as Phil mentioned, I mean, it's been 100%. And I expect it to always remain very close to 100%, even if we don't keep that perfect record. Now, this new guidance from the Department of Education that we received for loans owned by the Department of Education, it doesn't explicitly apply. It's not, no court is going to be bound or no opposing attorney is going to be bound by this guidance when it comes to a private student loan. But that doesn't mean that this guidance won't start to become pervasive as one way, as maybe the way to demonstrate undue hardship, right? As this guidance starts popping up in cases and public federal student loan cases start settling and the judges start signing orders, discharging student loans, there will be an enormous amount of pressure and also just some convenience for the private student loan lenders to start kind of following similar guidelines. It makes perfect sense. It will be efficient for them to use something that's a little bit more objective. And I will tell you, they already are the best cases. And so to have some objective guidance to where they can justify the attorneys that the private student loan lenders hire can justify discharge by kind of going through and checking off some boxes, I think will make perfect sense to the private student loan lenders, to those banks. So understand this guidance, know it, learn it, understand what justifies undue hardship, and then don't be afraid to let your clients know that there might be an option to discharge their private student loans, even get a full discharge. Now, again, as we've talked about in previous videos, you have to be serious about it. This isn't just like, hey, I'm just going to throw this over the wall and hope that I get a discharge. You have to be willing to gather facts, understand the legal argument, draft a great complaint, and be serious about taking the case to trial if necessary. But if you do those things, you will have surprising results. They were even surprising to me when I started doing this about 18 months ago. I anticipated an 80% success rate, which I thought was actually pretty optimistic. And it's been much higher than that. So don't be afraid to take these cases, or to at least offer these options to your clients and have us do the legwork for you, because this is just, you will not see happier clients than clients who thought that bankruptcy could not help them with their discharge, could not help them with their student loans at all, and all of a sudden they're getting discharges of their student loans. It's incredible, the kind of relief and excitement that you'll have from your clients.
Ken, let me jump in a couple of things. First of all, the distinction between private student loans, as we've talked about in previous videos, and loans that they call themselves student loans, but they're not even student loans, right? I mean, like they're distinction. A lot of your debtors are going to come in and they're going to say, oh, I have student loans, but they actually don't. They have private student loans. That's a key distinction. They just want to educate these consumer bankruptcy attorneys who may not know, right? Yeah. And share where you can go to find out, to confirm that with the, for their specific circumstance.
Yeah, absolutely. So here's just the dirty secret of private student loans, which is a lot of them do not even qualify as being accepted from discharge under A8, under 523 A8. They're not qualified loans because the lending in the school for which the loan was made is not a qualified school under Title IV. And if that's not the case, then it doesn't meet the requirements under the Internal Revenue Code that are required in 523A8. Go read that 523A8 and you'll see that it references the Internal Revenue Code. Those are only schools that are qualified to give federal loans. So if the private loan wasn't given for an education at a school that's also qualified to give federal loans, then it's not a qualified private student loan. Now, will the lender ever tell you that? No way. They're just going to call themselves a student loan and say, we weren't discharged, pay up, because they know that out there the prevailing belief is anything that's even remotely related to education is not discharged, right? It doesn't matter if it's unpaid tuition. It doesn't matter if it was a boot camp at, a little community center that 4 people showed up, but it was called a school. So it's a student loan. Those are dischargeable, right? And you got to bring that case and you got to get that determination from the court that it is dischargeable. I'll tell you that those lenders generally, they know as soon as you file the complaint, they say, yeah, you're right. Sorry, we weren't a student loan. And they just either don't even respond to the complaint, they let it default, or they stipulate to a judgment. So look for those. Those are all over the place in your cases. Go through your last 50 cases. Mm-hmm. You're going to see some of these like boot camp type loans that they're not student loans. They should be discharged.
And when we just recorded a video on creating a complaint, do you build the complaints the same? It doesn't really matter whether they're federal or private, right? You build all the complaints plain.
Of course, this like non-qualified student loan argument we only make on private loans because all federal loans are qualified under 523A8. But so there are a few additional things we'll sometimes put in there for private student loans. Also the costs, was it actually used for the educational costs, right? The tuition, or was it used for something else? Because only there are cases and there is law in some circuits that says only the portion used for education is qualified. So there's a few additional arguments, but by and large, it's really about having a well-researched, having good facts and knowing the facts and having the evidence, and then knowing the law, and then just being serious about getting a good result. Opposing counsel will see that you're serious. They don't want to spend a lot of money fighting this. They don't want bad case law. They don't want to go to trial and have a ruling that's in favor of the debtor that creates weakness in the case law. So just be willing to show how serious you are about it, and to be willing to go the distance, and you'll get a good result for your client.
And, I want to point out, a lot of bankruptcy attorneys, I hear them tell us, well, this wasn't a lead because they only had $4,000 worth of debt, or this wasn't a we couldn't file bankruptcy. There's debtors out there that have gone to boot camps, as you say, Ken, that have spent 10, 20, $50,000 on a get rich. Let me show you how to make money online. Let me show you how to make money in real estate. Let me show you how to fill in the blank.
Yep.
I mean, it's
Get some kind of
outrageous.
technical certification is a big one, right? Like get
Yeah.
this certification, which maybe doesn't even really help the person that much, but it cost them $25,000 to go through this 1 month program. And yeah, those are by and large, almost universally, those are dischargeable.
Yeah. Well, just to close the loop and watch our other videos. So Neely Law is out of Arizona, but you handle cases nationwide with attorneys all over the country. His website is studentloanrelief.us, studentloanrelief.us. We will have this link below. When you find a debtor, if you don't want to do the work inside, if you want to do the work in-house, great. You can take this information and use it. If you don't want to do the work in-house, you find a debtor, you put their information here, you put your name here, how they heard about you, right? Your name, your attorney name, and you'll be logged as, however you want to describe it, Ken, co-counsel, or you'll fee share or a referral fee. Speak into that, Ken.
Yeah, we'll just make sure that it complies with your rules of professional responsibility, of course. In most cases, we will hire you to be local counsel because we may not be licensed in your state. And so we need local counsel there to file that adversary proceeding. And so in any state, we can pay you as local counsel. That's not prohibited in any state for us to hire you and pay you a reasonable fee. In states where we don't need you as local counsel, we'll just make sure it complies with your rules. And we're paying generous fees on these cases to our referring partners and doing cases across the entire country.
Well, the best part, I mean, what I've heard from our bankruptcy attorneys that use you, the nice thing is one, they're not learning something. They're not having to hire more staff. They're not writing out complaints. They're not litigating, which is different than bankruptcy law, one. And two, you submit their name and they get calls. I mean, as a matter of fact, one time someone submitted their name and got a call while the person was there. You guys were so fast, right? Yes. So it's just one of those things that this is extra revenue. On previous calls we've talked, you can increase your case value $400 to $500 per case by looking for student loans, submitting it. And because the reason why it goes up so much, there's going to be some people who would not file bankruptcy, but now they're going to file because of this option. And from our perspective, 720 System Strategies, we help consumer bankruptcy attorneys become more profitable with generating leads, follow-up, and Google reviews, and just helping you run the back-end tech support of marketing. And that's what we do. You can go to our website below, 720 System Strategies, to learn more about what we do so that so you can take advantage of this incoming wave of bankruptcies. Ken, thanks for your time. We're going to now record on how to charge, and keep an eye out. These videos are going to keep coming around student loan discharging and what that means for 2023.